So it's not just a question of what the legislature enacts, it can take away. There's no fundamental
it is not like that, my lord.
But
yes.
when you are making an enabling provision for contributions,
my lord,
and taking away the restraints on companies,
yes,
the taking away of those restraints is amenable to be tested.
Is amenable to be tested on manifest arbitrariness, my lord.
One level,
my lord,
all this has been regulated by statute.
My lord.
Right from 1956.
My lord.
The nature of the regulation has been by statute.
My lord.
The only point is this: absent an enabling provision in the statute, namely the Companies Act, no company can donate for political purposes at all.
Yes.
Right?
Yes.
So though at a certain level or at first blush, this is regulated by statute.
What
is conferred by statute can be taken away by statute. All right? No implication of a fundamental right can arise. So for instance, just wait a minute.
My lord.
It may not be against you.
Yes, no, I'm not.
Suppose there was no provision in the 1956 Act at all for political contribution. What would be the consequence? Consequence is not that companies are free to donate for political purposes untrammeled by any other provision. The 1956 Act, for the first time, when that enabling provision came, provided, in fact, there was a complete ban. 1960 was 5% of the net profits or 20,000 rupees.
My lord.
Absent that provision, you could not have contributed at all.
My lord.
Then comes the ban in 1969. Ban is lifted in 1985. So though it is a matter of statutory regulation, absent an enabling provision, a company cannot contribute to political purposes.
My lord.
So if the constraints subject to which those contributions are permissible are lifted by the legislature,
my lord,
they are amenable to be tested under Article 14.
Article 14. Yes, my lord. And it is manifestly arbitrary, my lord. There are two reasons which are given.
So it's not just a question of what the legislature enacts, it can take away. There's no fundamental
it is not like that, my lord.
But when you are making an enabling provision for contributions,
my lord,
and taking away the restraints on companies,
the
taking away of those restraints is amenable to be tested.
Is amenable to be tested on manifest arbitrariness, my lord. Because, my lord, there are two objects which are given. To give transparency, I'll show to your lordship that only two objects which are given, my lord, for amending this.
Seen now. I mean, transparency and other things you cannot repeat because that your predecessors all argued.
Very well. So it is amenable to be tested.
But this was very valuable because you have given us the complete list.
My lord, I'm grateful to you, lord.
Now, what do we from here?
Now, would your lordship see similar changes in the Income Tax Act?
All right, let's see the Income Tax.
Yes, my lord. Which are in, my lord, page 12 of my same compilation.
12. Yes.
Evolution of income tax, page 12 of volume 1A. Benefit in the context of political party amendment to not to keep the records and yet granting tax benefit in contradiction to the initial object behind introducing such benefits. Now, section 13A was introduced in the Income Tax Act 1969 in 1978, whereby the income of a political party inter alia from contribution receipt was exempted. The exemption was provided to address the issue that such taxation of their income reduces their disposable funds, adversely affecting their capacity to finance their activities from the legitimate source of income. Then, my lord, I have quoted the objection regions. Lordship may just skip over and see the top of it, page 13. Now, that was regarding the Companies Act. Now, this is regarding, my lord, the political parties. Heading of page 13, exemption will not be allowed unless the political parties maintains proper books of account, records the name and addresses of every person who has made voluntary contribution of more than 10,000.
You're reading the statement.
I'm reading the statement of regions. Then I'll come to the section. And accounts political audited by the chartered account. And then section 13A inserted by 1978. Special provisions regarding to income of political parties. Any income of political party which is chargeable under the head interest of securities or interest from other sources, or any income by way of voluntary contribution received by a political party from any person shall not be included in the total income of the previous year of that political party, provided. Now, my lord, it's exempted provided. These provisos are important. Such political party keeps and maintains such books of account and other documents as would enable the income tax officer to properly deduce its income therefrom Now, Lordship has seen yesterday, my learned friend Paratha said, one DV, KV has given 1 lakh and that is exempted, my lord, without details. My lord, my submission would be, my lord, when it comes to the scrutiny of the political party's income, my lord, nobody applies its mind. The income tax officer should have said, my lord, you are required to disclose details, accept cash of 1 kV, my lord, of 1 lakh rupees. Page 5553, my learned friend Mr. Farah has showed that, my lord, to your lordships. And that is accepted. Whereas the requirement of Income Tax Act that you must books of accounts so that the income tax officer properly distributed income from. Second, in respect of such transaction in excess of 10,000 rupees, such political party keeps and maintains a record of the contribution and the name and addresses of the person who made the contribution.
What is the next? Thereafter, what is the
Yes,
change
my lord.
made?
And my lord, this then political. Then this, my lord, has been changed in 2003.
Where is that?
Next page, my lord, page 14. And my lord, I have quoted the statement of objection regions that may not be lordship, may not, or I can read that, my lord, because 2003 as the large number of changes in the Income Tax Act, my lord, and the electoral bond trust number, I'll invite your lordship's attention as it came, my lord, it was introduced. To keep the identity of the donor, my lord, which is being said corporate houses to be secret, my lord, not to go in public domain, etc. The purpose of one of these things is said that has been taken care of by electoral trust. In 2003 amendment, my lord, the objection regions, Mr. Law Minister's statement is quoted. Lordship may skip over that. I have given the region, my lord, as the bold portion. May I read, my lord, at page 15, the bold portion, middle of it.
Let's read this para 10, which gives sums up what happened.
Yes, my lord. Para 10.
So till 2003, there was no equivalent of 80 GGB and 80 GGC.
Please, your lordships.
So at that time, therefore, these donations will not be covered by section 37 of the Income Tax Act.
Yes, my lord. No, section
37
13A.
is the expenditure clause.
Lord,
They will not be covered. It's not wholly.
the donor will not get, my lord, the exemption.
Donor will not get the exemption.
Yes, the political party is receiving, my lord.
They are exempt.
Their income is exempted provided those conditions are met.
Satisfied.
But the donor will not get it.
Donor, it was not treated as expenditure in the hands of the donor.
Please, your lordship. And 80 GGB and 80 GGC. Would your lordship see this section? Lord, it's not available on record, my lord. I have given the books.
Who upload for 80 GGB or 80
Yes, I have
GGB?
given in the one.
Make to politician.
Who?